Hi, welcome back to my channel. Today, we're going to dive into the tricky world of Medicaid rules to see what really happens when you transfer assets. When it comes to planning for long-term care, understanding the rules of Medicaid is crucial. One of the most critical aspects of this is transferring assets, which can greatly impact your eligibility for Medicaid benefits. In this video, we'll explore what happens when you transfer assets under Medicaid rules and why it's so important to get it right. I'm a consultant that has guided over 200 families through the Medicaid long-term care application process. I'm not an attorney. Grab a pen and take some notes. Many people who are planning for long-term care face a difficult dilemma. On one hand, they want to qualify for Medicaid to help cover the high cost of care. On the other hand, they also want to protect their hard-earned assets, such as their homes, savings, and investments. Those two goals can seem mutually exclusive, making it challenging to navigate the complex rules of Medicaid. One of the main challenges is that Medicaid has very strict rules about what constitutes a qualifying transfer of assets. If you transfer assets incorrectly or at the wrong time, you could end up disqualified from receiving Medicaid benefits. This can lead to a significant financial burden, not only for the individual, but also for their family. Additionally, many people are unaware of the specific rules and regulations surrounding asset transfers under Medicaid. Without proper guidance, they may unintentionally trigger penalties or even disqualification from benefits. It's essential to have a clear understanding of these rules to avoid the costly mistakes. Unfortunately, even with the best intentions, it's easy to get it wrong. One of the most critical aspects is the look-back period, which is usually 5 years. What does the look-back period mean? Well, during this time, Medicaid examines all the asset transfers for the past 5 years. There is a specific specialist assigned to review your bank accounts, property, things like that. They can't see details like you can. For example, if you went to Costco and bought gas, they can't see that. They can see how much was in the account at the beginning of the month and how much was in it at the end of the month. If there is an unusually large amount that was deposited or withdrawn, like more than you would normally have, for example, if you bought a mattress or you sold a house, that would trigger a flag. And that flag would have the specialist say, I want to know more about this. They would want to ask for statements around that bank account, specifically surrounding that deposit, usually the month before the deposit or withdrawal, the month that it happened, and then the month after. What they're looking for is to determine whether the transfer was made for less than fair market value. For example, if you sold a car to your grandchild for $100 and it was worth $5,000, that's a transfer that was made for less than fair market value. If the specialist determines that a transfer was for less than fair market value, then they would share that information with the penalty board. If the penalty board determines a penalty is necessary, a penalty will be imposed, which can significantly delay or even disqualify you from receiving benefits. Another essential aspect is the concept of countable assets. These are assets that are considered available to pay for care, such as cash or savings and investments. You can download a general list of countable assets in the show notes. It's essential to understand the rules and regulations surrounding asset transfers to avoid these pitfalls. For example, you can transfer assets to your spouse without any penalty. But transferring $10,000 to an adult child to help them pay for a dental bill at the same time your spouse needs memory care, well, that's going to be a flag. Penalties can lead to significant financial burden and stress, especially during a challenging time. For example, when I was working with Shirley several years ago, her spouse had been in memory care for 2 years, and Shirley wanted to preserve the remainder of her retirement savings. When I asked her about transferring assets in the previous 5 years, she mentioned that she had helped her grandchild pay for a portion of his college in the previous 12 months. The state reviewed that transfer. They did a little math. The penalty board takes the amount that Shirley gave to her grandson and divided it by the average daily rate that it cost to pay for care, and they assigned Shirley a 6-day penalty. What that means is, even though Shirley had done everything required to have her spouse qualify, she had to wait those 6 days before Medicaid would begin to pay for her spouse's care. It's essential to remember that Medicaid rules are in place to ensure that only those who truly need long-term care benefits receive them. However, this doesn't mean you can't protect assets. With the right guidance and understanding of the rules, you can transfer assets correctly and maintain eligibility for Medicaid benefits. Many times I get calls from children of aging parents who've helped their parents move, so they can move closer to the child. The child's paid for moving expenses. The child can get reimbursed for those expenses. That's not a problem. The key is to keep track and keep your receipts. Another concern about transferring assets is whether a child or grandchild can get paid for caregiving. The key to paying for caregiving and avoiding penalties is to create a caregiver agreement. If you check in the show notes, I'll have an example of a caregiver agreement. This agreement is between the person who needs the care and the caregiver. The agreement would list the care that's provided and the amount the caregiver is going to get paid for that care. Both parties would need to sign the agreement and date it. It's great if you can get it notarized at the bank, but a notary is not required. I'm often asked if the caregiver agreement can be backdated. The answer is no. But creating one now and moving forward is a good idea. In summary, Medicaid rules and the intricacies of asset transfers is crucial for individuals planning for long-term care. Don't give your house to your child to qualify. That's a bad idea. There are ways to give relatives your home in exchange for care that they've provided for you, and we'll go into that in another video. You have to do it the right way. By grasping these concepts, you can avoid costly mistakes and ensure you're eligible for the benefits that you need. There is so many more details about transfers, and I'll be working towards creating videos that answer unique situations. If you're looking for more information on Medicaid planning strategies, be sure to check out our video on how important it is to be organized, for example. If you have any personal experience with Medicaid transfers, share them with us in the comments below. And remember, I am a guide. Your situation might need an attorney. Not all elder law attorneys understand Medicaid law, and that could cost you thousands. So do your homework. If you find this information was helpful, take a minute and subscribe and share with your friends so that they don't make any mistakes either. Thanks for watching, and I'll see you soon.